Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us, coming to you from Washington's nicest indoor shooting facility. Of course, that's Security Gun Club right here in Woodinville, Washington. Hey, it's not often I get to do a video with this much good news to it, but as you probably heard last night, there was a huge ruling as it relates to ATF's rule on firearms with attached stabilizing braces, or what we call the Pistol Brace Rule here. And this ruling has effectively, and for now at least, killed ATF's Pistol Brace Rule. So today, let's get you educated. Let's go through the order and let's talk about how ATF's Pistol Brace Rule just died. Okay, so I know I'm a little late to the party. This news broke late yesterday. I rearranged my schedule because, as you do know, I try to run a law practice also, so I could get up here to Security Gun Club, get this video shot before the lunch hour out here on the West Coast, and get it out to you. The case we are talking about is Britto versus ATF. It is a case that is filed in the United States District Court for the Northern District of Texas in the Amarillo Division. Now, we have talked about this case before, as well as other cases related to suits about ATF's Pistol Brace Rule. Now, there has been several injunctions already issued by multiple courts. Those injunctions, however, applied to the named plaintiffs in those cases, and in some instances, members of certain Second Amendment organizations. But there was no such thing as a nationwide injunction, and in fact that issue had been raised in multiple jurisdictions only to have that shot down. However, and this is the good news, is that in the Britto case, this court has now enjoined ATF's Pistol Brace Rule on a nationwide level. Let us celebrate. Now, one would think such a momentous ruling would have a huge order and opinion attached here too, but the good news is it's only 9 pages long. And the reason that it is only 9 pages long is because the court very wisely cut directly to the chase here. And so even though there are multiple challenges to ATF's Pistol Brace Rule, as a matter of fact, the plaintiffs in this case raised the following challenges. 1, the rule violates the Second Amendment. 2, the rule violates the separation of powers and non-delegation principles. 3, the rule conflicts with NFA's definition of rifle. 4, the rule is arbitrary and capricious under the Administrative Procedure Act. And 5, the rule is void for vagueness. But the way that the court was able to cut immediately to the chase is that, well, there's already some pretty good binding precedent in the matter of Mock v. Garland. Now, that is an equal challenge to ATF's Pistol Brace Rule, but as we know, that court has enjoined the rule, said that the plaintiffs are likely to prevail because the rule clearly violates the Administrative Procedures Act, or what we call the APA. And the court here is of the exact same opinion. So rather than get into all of the other challenges that plaintiffs raise, which I will point out are all very valid and legitimate challenges that they likely would prevail on as well, the court here has said, hey, listen, it's obvious it violates the APA, and for that reason the rule is dead. As the court specifically ruled, under the APA, courts must hold unlawful and set aside agency action, findings, and conclusions found to be arbitrary, capricious, an abuse of discretion, or otherwise not in accordance with the law or in excess of statutory jurisdiction, authority, or limitations, or short of statutory right. And again, with the precedent of Mock v. Garland already there, the court was able to get there. Now, even though there was multiple constitutional claims, predominantly under the Second Amendment, the court said, hey, listen, there is significant case law that says if we can resolve this issue on other grounds rather than getting to the constitutionality of the statute, that is exactly the route the court should take. Or as the court pointed out, it goes without saying that constitutional questions should be avoided if there are independent grounds upon which the case may be disposed of. Further, the Supreme Court has encouraged lower courts to avoid expending scarce judicial resources to resolve difficult and novel questions of constitutional or statutory interpretation that will have no effect on the outcome of the case. And so what the court is saying here is, listen, why waste all of our time? There's a very simple answer to this, which is, hey, this violates the APA, and the remedy is to strike the rule down. Now, For those of you who've been geeking out on this channel for a while now, you know that there is actually a two-part test in order to get injunctive relief. Number one, the plaintiffs must show that they are likely to prevail on the merits, which is exactly what the court has found here. Number two, they must show irreparable harm. And as you also are aware, because you geek out on this channel all the time, that, the United States government consistently argues, hey, wait a second, they can still have guns, they can still defend themselves, so no harm, no foul. Where's the irreparable harm? And the court here was not persuaded by that argument either when they ruled because the mock plaintiffs owned firearms and stabilizing braces that the final rule would classify as an SBR. The plaintiffs had no trouble establishing a substantial threat of irreparable harm in the form of non-recoverable compliance costs. The same is true here. And then ultimately, and the coup de grace to this ruling is the court went through a very thorough analysis, albeit brief, but very succinct analysis as to why a nationwide injunction of the pistol brace rule is appropriate. The court ruled as follows. For similar reasons, this factor supports injunctive relief. As explained in Garland, the controlling law of this case is that the government's defendant's promulgation of the final rule fails the logical outgrowth test and violates the APA, and therefore must be set aside as unlawful under the APA. It follows then that there is no injury that the government defendants or public at large could possibly suffer from if enforcement of the final rule were enjoined. Now, of course, one of the arguments that the government has made on this case and any other case involving pistol braces is that, listen, they're just circumventing the NFA. They're just working around. Are you going to actually let them circumvent federal laws? Now, the court was not insensitive to that idea, but brushed it aside as follows. The court is not insensitive to ATF's concern over gun industry gamesmanship and attempts to circumvent the NFA's restrictions on SBRs. However, the government may not simply posit that the regulation promotes an important interest to justify its regulation. Of course, some form of protest can be expected when constitutional rights are allegedly infringed. The passage of time and the development of new technology can also reveal latent ambiguities in a statute. And of course, the final and last argument that the United States government always makes is how many lives are going to be cost by this absolutely ludicrous ruling. The court responded as follows. Likewise, the court is certainly sympathetic to ATF's concerns over public safety in the wake of tragic mass shootings. The rule embodies salutary policy goals meant to protect vulnerable people in our society, but public safety concerns must be addressed in ways that are lawful. This rule is not. For the foregoing reasons, the court grants the motion and stays the rule in its entirety. So, if you are watching this video, as of this moment, the pistol brace rule has been enjoined on a nationwide basis. This means not only if you've done your amnesty registration or if you're a member of one of those organizations that were named plaintiffs in various lawsuits, you already were enjoined. However, if you are just a lawful and responsible gun owner who purchased one of these firearms lawfully, owned one lawfully, and suddenly woke up one day to find out you were in possession of an unlawful NFA item, congratulations, the rule is enjoined for you as well. The case, once again, is Britto versus ATF. We will link it up down below so that you can geek out on it. Obviously, the United States government will appeal and there will be more developments. In the meantime, if you guys got any questions about this or anything else related to what's left of your Second Amendment rights, you guys should know how to get a hold of Washington gun law by now. If you don't, that's okay. That information is also down there in the description box. Now, in the meantime, let's remember that part of being a lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. Until next time, thanks for watching and stay safe.